Okay, hello, welcome everybody. Thank you for joining us. This is the second episode in our Managing Risk in Construction series. Today we're going to be talking about risk mitigation in PI insurance. I'm John Pennick from Barclays Insurance, expert in professional indemnity, and I'm going to be in conversation once again with Derryn Rolfe from Roythornes. Derryn.
Good morning. Thank you, John, and welcome everybody. I was about to say nice to see you all, but actually I'm not seeing you at all, but nice to have you with us. Yes, so we're going to talk about professional indemnity insurance. So this time it's mostly going to be me asking the questions and John answering them. Yeah. So the first thing, of course, is what is PI insurance? And how it works. So, John, give us a beginner's guide.
Yes. So PI insurance it is there to protect professionals, and today, obviously, we're thinking about construction industry professionals. So anyone involved in providing professional services, whether that be design or advice or management services, if you're providing any professional role, then that means that you are potentially open to being sued by anyone who is relying on your professional advice. And in the event of you being sued and you being legally liable, then provided you have PI insurance, professional indemnity, then that is designed to defend you and to settle that claim against you.
So is this something that this isn't a legal requirement for people to have? It's a sort of commercial sort of good idea more than anything else.
Yes, I mean people buy PI insurance for a number of different reasons. Usually, it's a requirement by the clients who they're working for. So if you're involved in work on a construction project, then the employer will nearly always insist that you hold PI insurance, or if there's a bank involved or anybody providing finance. So it gives them reassurance that you are protected in the event of them needing to bring a claim against you. So that's usually the most common reason why people buy PI insurance. Those who are more minded to protect themselves against the risk posed by getting their advice wrong would be buying the cover voluntarily and would want to be protecting the business, because in the event of a claim being brought against them, if they weren't insured, then they may not have the funds to defend themselves or to settle that claim. So that's one other reason why people buy the cover. But generally, it's usually somewhere in between. People realise that commercially they need the cover, and without it, they're unlikely to get any work. And how much they buy is then the main consideration. And again, that's either determined by what they need to work for particular clients and for particular size of projects. But again, it's making a decision on how much cover otherwise you would want to have to protect the firm.
There are, so for example, solicitors and I think doctors and dentists are required to carry PI insurance. We're not allowed to practice without it, but that's not true for any of the professionals in construction, is it?
Well, it rather depends. So if you're an architect, for example, and the ARB requires you to hold a reasonable level of insurance, if you are an RICS chartered surveyor, then you do have to hold professional indemnity insurance. But others, the rules are a bit more relaxed, and certainly there is not the same strict requirements that, for example, solicitors would have.
Yeah. So if you don't have it, and provided you don't want to simply leave yourself open up to the risk of a claim, can you do anything else? I know I used to be in the process industries, and it was very difficult for designers to get PI insurance because it was felt that, certainly in the larger end of the industry, the underwriters simply wouldn't take on the risk of a piece of negligent design taking out an oil refinery plant, for example. And so most people used to limit their liability simply by contract. But I think the world has moved on. That's probably not so common anymore.
No, it's a really good point, because I think a better way of looking at this, and obviously it's a theme of our series of conversations. It's managing risk, it's mitigating risk, and I think if you think of this more as risk rather than a pure insurance matter, and then once you think about this purely in terms of risk, it's then thinking about how much risk you're prepared to accept yourselves.
Yes.
How much risk you want to transfer. So insurance is a risk transfer mechanism. So instead of keeping that risk to yourself, you're transferring that risk to your insurers. And then in between that, rather than being uninsured and being insured, in between there is a thinking about how much risk that you are able to tolerate between being insured and uninsured. And that's where we think about things like the policy excess. So in the event of a claim against you, how much you're prepared to contribute towards that claim. And also the amount of cover that you buy. So for example, if you're involved in, let's say, a contract with a £20 million construction value, then you might decide, well, actually the amount of the potential claim against me as an architect, for example, may not be as high as 20 million. And you might decide, well, actually, we'll only insure for claims up to 5 million. But obviously, there is a risk potentially there that a claim could exceed 5 million. And then that's that risk that you're taking back and absorbing yourself. So I think, the starting point with all of this, and we'll go into more detail about how understanding risk will benefit you. But the starting point is understanding risk, understanding your tolerance for risk, and how much financially you're prepared to accept as a risk yourself, and how much your clients are prepared for you to absorb as your own risk.
Yeah, I mean, in that respect, thinking about things like the deductible, the excess, it's no different really to buying car insurance. How much am I prepared of my own money to put on the table if I drive into somebody? Because presumably, I'm off, I don't know, but presumably, if you have a higher excess, it's going to keep the premium down?
Yes, in theory, and up to a point. So the way that the policy excess is applied, and how much policy excess an insurer might want you to take, will very much depend on the nature of the risk that are being asked to insure. And quite often there is a sort of a bit of negotiation that takes place between the insured and the insurer as to what that policy excess might be. If it's too high, for example, and you're taking too much of that risk yourselves, then insurers want to be satisfied that you have the ability to pay that, because in the event of one or more claims of, let's say, in excess of £50,000, then you obviously need the ability, you have to have the financial ability to pay that amount of money. But at the more lower end of the spectrum, when it comes to the policy excess, if you've got a £2,500 excess and you decide, actually, in the event of a claim, we could probably dip into our pockets more. If you went up to £5,000 or £10,000, usually you would, the premium would come down. What I would say is it probably won't come down as much as you would expect it to.
No.
And most of the time, what we find is that the insurers who are providing the different quotations will usually have their own idea of what the excess would be. And it generally sort of evens out, and there's sort of like a standard excess you'd expect for a firm of a certain size carrying out certain types of work with certain contract values. So there isn't much in the way of negotiation a lot of the time that's meaningful, but occasionally when the circumstances are right, and usually, as you alluded to there, where there's higher risk work, then that's where insurers have different views as to what the policy excess ought to be to satisfy how much risk they're prepared to take on.
And I do have one client that's part of a large group, where their excess is 500,000. Well, at which point you think, well, actually, what's the point in having it? Because there's not a huge number of claims which is actually worth making if that's what the excess is. But so you talk about the lack of negotiation on the excess, but is there much negotiation on what the policies cover? Do policies differ very much?
Yes, they can do. Probably not in a way that makes much material difference. To us as specialists in this, those little details can be significant depending on the nature of the work. So it's really in the detail where we like to focus our attention for certain types of professionals. So what I mean by that is that a lot of professional indemnities are fairly standard in terms of what the core cover is.
Yeah.
So at the heart of a professional indemnity policy, it's covering people for claims as, loosely speaking, as a result of a negligent act, error, or omission. A lot of policies can go beyond that to cover more generally what's described as civil liability.
Right.
And if you are a chartered surveyor, there's a particular policy form that most of the markets are following. And if you are an architect, similarly, the policies are constructed in a particular way. Now, where the differences lie and where it's really important and to engage with experts on professional indemnity is for firms that are carrying out particular types of work that might not automatically be covered because that type of work would be excluded. So what I mean by that is, for example, if you're a professional firm involved in giving design or advice on matters relating to pollution or asbestos, typically they're covers that are either very limited in their scope within the policy cover. There might be a lower sublimit, or it might be excluded completely.
Yeah.
More recently, most people in the construction industry that buy PI will notice that the cover in respect of cladding and fire safety related claims has either been excluded or heavily restricted. That's changing, and conditions in the market are improving. But most people found in the post-Grenfell world that the cover that was previously unlimited or up to the normal policy limit was severely restricted, and we're still dealing with the consequences of that in terms of the policy cover. So,
but that's sorry to interrupt. That's relaxing a bit, is it?
It is. It's improving very slowly, very subtly, and for firms that haven't got much of an exposure to fire safety related risks, then they're seeing the benefits of that improvement within the market. Other firms who have had an ongoing exposure to cladding related risks and fire safety in general, it's going to be slower for things to improve in terms of what the market's prepared to cover.
But it will. That's it. I mean, is that as a direct result? Sorry, this is off topic. It's direct result of the fact that the cladding problems are being identified and they're getting fixed now.
Yes.
So there's a view that actually the claims are going to be.
Yeah. So where that cover is starting to improve, there's usually been a cut-off point.
Yeah.
And insurers are saying that they're either not covering work prior to a certain date.
Yeah.
It's what we call a retroactive date. So they'll have a cut-off point. Anything before that date will either be excluded or severely limited in the scope of cover.
Right.
And then for work from that date onwards, usually it's that point where everyone realised actually we can no longer specify those sorts of materials anymore.
Yeah.
Now, everyone's obviously very far more educated than they ever were, and those sort of products aren't available for use anymore anyway. So it means that insurers can be more relaxed in terms of for the risk going forward. Looking backwards, that risk is probably not going to be insurable for quite a few years, whilst all of the ongoing fallout of the post-Grenfell type claims are dealt with. But in terms of new work, that's where we're seeing the improvement there.
Okay. But I mean, it must have been sort of a slight horrifying situation for the insurers when the limitation period was pushed back to 30 years before the Act.
Yes,
because
indeed.
Working on a year of claim basis, the people who are paying out for any claims are not necessarily the same underwriter that actually got the benefit of the premium at the time. So
exactly, and that wasn't helpful in terms of the way that the market was starting to improve, because all of a sudden insurers see there being more risk there. There's far more potential, and claims going far further back in time than were anticipated. Now, that's all theoretical. Whether in reality that many claims will emerge that will be significant enough to affect the market, my gut feeling is probably not. But it's not helpful when things change like that.
No, my gut feeling is the same, actually. I mean, I don't do litigation these days because I prefer not to, but certainly, over 30 years, the evidence is not going to be there. The technology's changed.
Exactly.
It would be very difficult, I think, in some cases. So I don't think it's going to be the mass claims that perhaps everybody thought.
No, I mean, the important thing to remember here is that even if those claims ultimately that might be brought aren't successful, the cover is there to design. It's designed to defend those claims.
Yes, exactly.
And all of the costs involved in defending those sort of claims, provided you've got that cover, the policy would respond to that. And when we talk about differences in the policy wordings, depending on the type of professional that you are, your policy excess may not apply to that defence cost cover. So, using your example of the client you come across with a £500,000 excess, if they were an architect, for example, then I wouldn't expect that excess to apply to the legal defence costs.
Just so that's claim.
Yes, so that's right. So just for the settlement of the claim, own defence costs, the excess wouldn't apply, and that's where that value of that cover would be felt immediately, because the insurers would pay for those costs from the ground upwards, as we describe it.
Interesting. To get back to the trouble is I can detour down these alleyways very easily. To get back to the list of things we were intending to talk about, key considerations when arranging cover. Now, one of the things that you suggested was important was explaining your services to
indeed. So anyone with any familiarity with buying PI insurance will know that at some point there's a form that needs to be completed. Usually it's every year. So when the policy comes around for renewal, there'll be a form, and that tends to ask a lot of the information, not entirely everything that's useful, and I'll come on to that in a second, but it's asking for information on the key things that the insurers need to underwrite the risk. Most important there is making sure that those services are accurately described to insurers, and the form will have different boxes for different types of work, and the form will ask you to break down your last completed financial year fee income into those different categories. And that will be things like architecture, civil engineering, project management, project coordination, etc. Now, the reason why it's important to make sure that your insurer fully understands what you do and the nature of the work, etc., is that if you put that work in the wrong category, then you will be charged a different premium rate, because those different areas of work have a different premium rate. So, for example, if insurers see that you've got a fee income of 10 million, and in the split in work, 50% is architectural work, then they will have a particular premium rate which will apply to 50% of the work, so 5 million. and let's say 25% is civil engineering, then 25,
Different rates apply.
2.5 million will apply to that. And the larger the firm is and the more fee income it is, obviously the bigger difference it makes if you put in the work in the wrong category, because you might end up being overcharged for the risk.
Or underinsured.
Or if insurers find out, well, actually, so this is the other thing to look out for. If you're not declaring that work properly and accurately, and you end up having a claim involving that work, and you've underdeclared it, and you should have actually been paying more premium, then that potentially is a problem. Insurers may take issue with the fact you haven't paid enough. But I would say more importantly, and going back to your original question about how important it is to make sure insurers understand the services, is that if you are undertaking types of work that haven't been declared to insurers and you have a claim, the insurers will look to, initially they'll look to the form to see if that work was ever made known to them. And if it wasn't, then chances are they'll say, well, look, you didn't tell us.
You're not insured for that.
There was no reason for us as your insurer to expect you to be carrying out that work.
Yes.
And that does happen.
Yes, I can imagine.
And now, if you've got good communication going with your insurance broker, then that shouldn't ever happen, because they will know you, they'll know the type of work that you're doing, and they will look out to make sure that that form is filled in correctly. So that's really important. Other things that are also important that make a big difference in terms of the premium and making sure you're paying the right premium. Also on the form, it's asking for things like largest contracts within usually the last 3 years or 5 years. So making sure that's accurately completed as well. So
that would be largest contract in terms of your fees, your income, rather than the project.
No, exactly. It should be the contract value.
Oh, gosh.
So it's normally the contract value. Now, we'll go on to ask what your own fees are out of that, but insurers will look initially to see what the construction value of that contract was. And this is where it can take more explaining to an insurer. So, for example, if you're a professional carrying out a very small area of professional work on a very large contract, for example, if there's £150 million warehouse project, and all that you're doing is the lower risk work, let's say you're doing the electrical engineering design, and your fee is quite modest compared to everything else, then insurers will then see that there's a really large contract on there. Hopefully they'll understand if you're explaining it properly and the form is accurately completed, that you're only involved in a small element of that work. But there's still a degree of risk there, because even though you are involved in a small element of that overall contract, that might be the most important part.
Yes, I mean, if it is electrical engineering, it might all go off in flakes.
Yes, or if all of a sudden, if there's industrial processes in there and they come to a halt because the electrics are designed correctly. So, these are the sort of things that insurers look out for. And when they get a measure of what the risk is and what the potential for a large claim might be, it's looking at those things. And naturally, if you haven't declared a large contract and then that large contract is the subject of a claim, again, that's a potential problem. And what we're always looking for as insurance brokers is for to avoid falling into the trap of things not being declared and insurers saying it's not covered. That's the worst case scenario for everybody.
Absolutely. You pay the premium that you think covers you, and it turns out.
Yeah, exactly. So I think the starting point is making sure, first of all, the form is completed correctly.
Yeah.
And there's a tendency to base the latest form completion on the previous years or the years before that, but sometimes all that's doing is replicating the same mistake that may have been made years ago. So it's always best to reevaluate the form before you complete it. Think about Have I received the right advice on how to complete the form? Am I doing it correctly? Is there work that needs to be declared? And then what also is helpful with the information on that form, and this is where the insurers won't be very helpful, but the broker will be, is where there is particular niche areas of work or areas that we know would be subject to restrictions in cover. So going back to what I said about pollution work, asbestos, cladding and fire safety related work, that's where we can look to make sure that the policy cover is going to respond to those sorts of claims, because there's no consistency amongst the insurers. The insurers only want to offer what they are prepared to offer. They won't give advice. You'd like to think that what they're offering is fit for purpose and suitable, but ultimately it's the advice from the broker, and for the broker, i.e. people like myself, to decide whether that is suitable for that firm.
Yes. I mean, ultimately, as I always say to people, the job of the insurer is to take your money and try and avoid paying out if at all possible. Ultimately, that's the contract. That's what they're going to cover, and it's not going to be anything else. There's no go, I'll add that in, be fine. They don't operate like that, so it's got to be accurate.
Yeah,
in terms of identifying sort of particular risks, that's where the broker is so critical. And I think that it's clearly the case that having an ongoing relationship with a broker, rather than shopping around every year, must give you a better cover in terms of having insured for the right things.
Yeah, exactly. You've hit the nail on the head there, because when it comes to professional indemnity, first of all, it's generally an insurance policy that people are paying a lot more than their other insurances for. For a lot of firms, it's their biggest expenditure after their wage roll. You want to be able to receive maximum benefit from that, and not necessarily in terms of making claims, because hopefully you wouldn't need to call upon the policy. But where you can extract benefit from arranging the professional indemnity cover and being aware of what it covers, is that it goes back to what I was saying at the outset about identifying risk, and the mere completion of the form, first of all, brings into focus you as a business owner or operator, what those risks are, because you're putting them in black and white on the form. If you're properly engaging with your broker, then throughout the policy year, if you're entering into contracts, and this is your area of expertise as well, Derryn, if you're looking at appointment documents, collateral warranties and the like, then it's really important that you understand whether the terms that you're signing on for will be within the scope of the professional indemnity cover. If your PI isn't going to cover things that you're signing up to for the next 12 years, then clearly that's problematic.
Your assets on the line.
But if you're getting proper advice on that, you understand how the cover works, and that's been explained to you, understand what the limits and the scope of that cover is, then it helps you identify those areas of risk that you are prepared to take on as a business. And this is really important, because we're in a world where contract terms, even though many people like to suggest they are standard forms, a lot of them, particularly, just off the top of my head, JCT standard forms of contract are not compatible immediately with professional indemnity. Most of those standard forms are subject to large schedules of amendment. It becomes very complicated. So engaging with your legal advisors, is highly recommended. Engaging with your broker so they can guide you on these things will really help when it comes to identifying risk, and it will help build your own understanding of how this works, and will help you understand where additional risk that insurers need to charge you for exists. And the more you understand about what actually is attracting higher premiums, the more you can factor that into how you might consider new contracts you enter into, particular contracts that might be problematic, and entering into large contracts that require higher levels of cover. Again, that's something that needs to be properly considered, because whilst you may get that upfront large fee for that work, if you then need to increase your PI cover for the next 12 years rather, exactly. If you've got a contract executed as a deed,
or 15,
yes, indeed.
Looking at BSA.
But if you're required to maintain that increased level of cover, then the economics don't always stack up. And again, engaging with a broker to help you understand what the implications of that are is really important. And once you've got that understanding, then it's a lot easier to not suffer market shocks when the market changes and you're used to paying a particular premium based on a particular risk. If your risk changes, what you don't want is to be left high and dry if the market thinks, actually, we don't want to insure you anymore. We don't want to insure you because you're doing this type of work. We don't want to insure you because you're doing contracts of this size. And that's where you've got an understanding from speaking to your broker about how to consider the medium to longer term impacts of that risk, I think is really important.
So, I mean, it's very clear to me now, frankly, in a way, I've never really thought about it. I'm not responsible for paying out PI, so it's not something I've ever had to worry about. But it does really make you think that every time you take on a client, you should be thinking, is this a job that I really should be doing? Does it bring any risks? I mean, apart from the whole, am I going to get paid issue? But is it something that it's going to affect me for the next 12 to 15 years? And if you do decide, not necessarily to diversify, but if you take on a contract of a bigger value than anything else you've done previously, I mean, is it a good idea to try and to talk to a broker about whether you need to increase cover, mid-term? Can that be done?
Yes, it can. Yeah, so provided the market is prepared to offer higher levels of cover, then you can arrange that mid-term through the policy period. So yeah, that sort of conversation can always be had, but thinking about contracts that you take on or diversifying into different areas, that's where you do need to be cautious. And where we've seen people come unstuck in the past is where they haven't really thought about the insurance implications. They thought, actually, we can probably dabble in that. If it doesn't work out, we'll just stop doing that. But the unfortunate thing there is you're on the hook for that. And depending on the nature of the contract that you've entered into, you could be on the hook for the next 6 years or 12 years or beyond. But in terms of your actual contractual liability, then, at the very least, we're talking 6 years. And then if you need to maintain that cover because either there is a risk there or the contract requires you to, then that could be problematic if insurers don't like that type of work anymore, or if there's a limited number of insurers willing to cover that type of work. So this is something we encounter quite often, where we've got professional firms involved in a niche area of work. Quite often
unfashionable because it's risky.
Exactly. And we see that. So in terms of environmental work, for example, there's a higher likelihood of a large claim. So we perhaps don't see much in the way of frequency of those claims, but
when they do,
they can be severe.
Yeah, the risks are low, but the hazards are high.
Exactly. And what that does, it creates a market for that type of work that's quite limited. You don't have necessarily insurers falling over themselves to offer cover.
No.
And if you've only got a handful of insurers that you can go to for quotations, and some of those insurers have their own claims from existing policyholders that have meant that they've caught a bit of a cold on that and decided to pull out of the market.
They're not going to be looking for new clients, are they?
No. So I think understanding that and understanding that dabbling in particular work, unless you're committed to it, and understand what that means in terms of not just risk, but in how that risk equates to premium is really important. But it also, it's important when we think about risk and how insurers view risk. It's a level of experience and expertise that you have within the business, and that's really important. And that's something that is identified very briefly on the form, and it is helpful quite often where there are specialist areas of work in particular where we would go the extra mile to demonstrate to insurers they can do this work. Here are the individuals who are experienced. Here's their CVs.
It might be a new startup firm, but the people doing it have all got 20 years experience.
Exactly.
So that it balances each other out.
That's right. And so this is where we go beyond just the information on the form, and we identify what additional information we know makes a difference.
Yes.
And identifying the quality of the employees, the people carrying out professional work, is important. Identifying any working procedures, company policies, quality standards, anything like that is really useful because, first of all, it demonstrates in a better way to an insurer that you're a firm that's thought about those things. It demonstrates that you've got a good handle on those risks and that you're doing your best to mitigate those risks.
So, for example, one of the things that you might put in place, that it might not directly affect the premium, but it might maybe affect availability or continuity or whatever, is looking at making sure that you don't just let anybody in the business sign contracts for anything, that you've got a system in place for proper review and understanding of what it is you're taking on, who the client is. What you wouldn't, for example, if you have a potential client who is known to be litigious, you wouldn't be looking at them for. Perhaps you wouldn't be looking at them for being your next and best thing, and having those systems to manage the risk internally, so that although there's always going to be a risk because things happen, but at least you've done your best to cut out the obvious, the easy things.
Really important, that is, Derryn. The understanding the contract terms that you've entered into, understanding and agreeing the scope of services. These are all of the things that a claim against you will focus on, and how successful you are, or the prospects of defending yourself successfully with a claim, will hinge on these sort of details.
I mean, it's quite fascinating to me, because I'm sad that I've been in private practice 26 years now, and when, having come from the process industries, when I came to private practice, it was the norm for consultants' appointments to use a standard list of services, and it was literally, they were in a book. Emden, we used to just take them out of Emden. That's what you did. It's an architect, those are their services. And in the time that I've been doing it, I can't remember the last time we used a standard service, because it's just ridiculous that of course they'll be doing all those things. No, they're not doing all those things. These are the things they've agreed to do. And I try to explain to clients that it's all very well me reviewing the terms, but if they have been provided with a form of appointment by their client, and that client has included a list of services, it needs to be the list of services that they have agreed to provide, not just any old list. Because if it just says, I don't know, act as the structural engineer, then anything that goes wrong is your problem.
Yeah, exactly.
And it's scary that people just, it's only this, just shove a list of services in it. And it really isn't that irrelevant. It's utterly critical.
No, exactly. And, you may inadvertently be liable for work that was never the intention. In the event of a claim being made against the whole team of professionals, it's really important to differentiate between your responsibilities and those of the others. And these are things, this isn't the fun part of the job, unfortunately. No. And it only really, the importance of it only really comes to light in the event of
a
problem and a serious claim.
And I do feel that I'm generally considered to be an absolute pain to be going, but is that actually what you're doing? Of course, no, don't give me the of course. I need to know exactly what you've agreed to. And further, I do have some clients who have the most wonderful in-house IT systems for doing this, and those are the ones that you think, yes, because they've got like a wedding list. Effectively, we're doing that. Yes, we're doing that. No, we're doing that. Yes, and that means that it's very clear language that says we are doing this, we are monitoring that, we are not controlling that, we are just reporting back on it, that kind of things that makes it clear where their responsibilities stop.
So important. And we see a lot of claims being brought by contractors who haven't managed necessarily the project on site particularly well. It's perhaps gone over budget, and as a result of that, they tried to claw back those losses from the professionals, and that means that that takes up a lot of people's time. First of all, to demonstrate, well, actually, me as the architect, I wasn't responsible for this, and this. The more that you've got that documented, the more that's clearly available and agreed and in writing, the easier it is to push back in that situation.
It's not your problem.
Otherwise, these just go down a cost of a hole of spiraling costs.
And then litigators win.
That's exactly
not what we want.
So the accuracy, there's a theme here. It's the accuracy of the completed form, the accuracy of the information in the contracts, its accuracy in the information that is supplied to insurers beyond the completed form, and these are things that make all the difference when the rubber hits the road. Really,
it's always the details. So, in terms of looking at the services in the contract, there's also the terms in the contract that you can look at to try and improve your position. I mean, exclusion clauses and limitation of liability clauses.
Yes.
I mean, I will argue either way depending on who my client is, fundamentally. People say, do you have a view? No, my job is not to have a view. My job is to get the best possible deal for my client. So it entirely depends on who's paying me as to what I think is reasonable. But there are certain clauses that are always an argument, like net contribution clauses.
Yeah.
I mean, they're and you get you say to acting for a developer, you'll say to the consultant, this is the proposed form of appointment. Can you have a look? And are you happy with the services? Is that definitely what you agree? Is the fees right? Can you check the terms? Come back to me. Tell me if there's anything you want amended, and then we'll look at it. And they come back with, if they sent it to their brokers, and some of them, I mean, sometimes I'll see the heading and I'll think, I know what the responses are going to say, because that particular broker says the same thing every time, and it's always, I want a limitation of liability and I want a net contribution clause. And you think, yes, morally I understand the concept of a net contribution clause. Commercially, it's not happening.
No. I mean, net contribution clauses have gone the way of the dinosaurs, basically.
But people every day of my week are trying to get them inserted in appointments and warranties. And no, you can't have it. Not
anymore. No, in an ideal world, that would happen, but no, certainly not.
But overall limitation clauses are a big battleground.
Yes,
I mean, you can see why they want them, and you can see why the client doesn't want them. So.
Yes, and this is where when we think purely in terms of risk, then that is helpful.
Yeah.
How insurers look at it will vary depending on how much attention they are paying to that particular contract. So, for example, if this is a large and unusual contract, and we're asking insurers to provide cover that they are uncertain as to whether they want to offer cover on, then those particular things make a difference. More generally, what we found is that insurers are quite skeptical of any clauses that limit liability or exclude liability. As you know, law isn't black and white.
No, exactly.
And some terms are capable of being enforced, others aren't. So insurers generally take the view, in a broad sense, let's say we're going to ignore that. But like I say, it is useful when we're having a conversation about a particular contract where it's a sticking point. We need the insurance. All of the lawyers are saying these terms have got to be in here, other terms. And then if we've got that around the edges that helps mitigate that risk, then that might just get it over the line. But, when we think purely in terms of risk and mitigating risk, which is what we're talking about here, then super useful.
One of the things that we see a lot, and this is where the limitation clause can come in, is the fact that sensible consultants and contractors will look at the job and they'll say, I'm only going to offer 5 mil, 2 mil, whatever it is. I've actually got 10, but I'm not putting it all on the table. And because of the usual wording of PI clauses in contracts and appointments and warranties, it can often actually end up being, even if you've got 10, even if it says you're only going to maintain 5, actually the whole 10 is actually on the table. So that's where your limitation clause would come in.
Yeah, exactly.
Is to try and protect the rest of your policy.
I think a lot of people confuse PI cover requirements in contracts with a limitation of liability, where the two things operate separately. Just because you're agreeing to provide, let's say, £5 million of PI cover and maintain that for the next 6 or 12 years or however long, doesn't mean to say that unless the contract says otherwise, they can still bring a claim against you more than that.
And if you've got more PI, that's fine. But if you haven't, that's your assets on the line.
Yeah, so exactly.
It is.
And the other thing to remember, obviously, is that you can't exclude liability for bodily injury anyway. No. So if you're designing a building that collapses and injures or kills everyone inside,
that bit is not going anywhere.
That's where the value of having a higher limit that reflects the nature of the risk is really important.
Absolutely. One of the things that I find a surprising number of, particularly consultants, I think most contractors are a bit more aware of it, aren't switched onto, is the fact that if they've got, say, 10 million, they don't have to, and somebody like me says, how much PI have you got? They can actually provide a certificate that says 5 million. They don't have to admit to having all of it.
No.
And your lovely brokers will happily give you a sheaf of certificates that you could use for, 1 million, 2 million, 5 million, 10, 20, whatever you've got. So make sure you don't always put all of your PI on the
no, because that's really good advice, because if all of a sudden you're agreeing, well, actually I'll maintain 10 million, and then that's, at some point in the future you might not want to keep that level of cover going. That was a one-off large contract and it's not cost effective to do that. If you wanted to lower it down to 5 million to save money, you can
do that because you haven't kicked yourself already.
So thinking about things in that way is really important. The certificates, we're providing those different levels to our clients all the time, and we'd word it to say at least 5 million or at least 1 million, and that's correct. It's not. It's not disguising the fact that high levels of cover might be available.
But it's saying you are required to provide 5 million. You say, we've got 5 million. We might have 50, but you don't need to know about that. Exactly. So it just ties up. It ties up nicely with the contract. And it's surprising how many people look at me in a kind of really fashion when I say, you've got the whole lot on this one. I go, I'm good about that. So we're running rapidly out of time here. But
shall we have one more question, and then we'll look at the Q&A and the chat.
Yes. So this is something that we are having constant, I wouldn't say battles, because we're nice people and we have happy conversations, full of frank exchanges of views. How about that? On the limitation periods, the 12 years, the 15 years. So our view is that if we're acting for the developer, we would like, and the 15 years limitation applies to the particular job, and we would like the consultants to be under a contractual obligation to be carrying PI for the whole of the 15 years. They always say, oh, no, we're only carrying it for 12. And we try and explain to them that there is a difference between the kind of the 12 years and the 15 years in that you can stop carrying your PI at 12 years, but you're still going to be liable for 15 years.
Exactly.
So it would be a much better idea if you were insured for those last 3 years. Because if something falls down, you've just wasted 12 years with a premium if it falls down in year 13.
Yeah, exactly.
And we're having this massive kind of, I mean, it's akin well, I think it's all wrapped up in the kind of still slow understanding of the effects of the Building Safety Act and everything that's come out of it. But your view would be 15 is a good idea.
Yeah, and it's not a problem in terms of the policy cover. Insurers aren't concerned whether you're entering into contracts where you're liable for 6, 12 or 15 years. Yeah. So from that point of view, it's not a problem. It makes sense to maintain the cover for that long, if only just to protect the business.
Exactly.
If you set aside the contractual liability side of things and you think we need to protect the business and its assets, then maintaining that cover for that period of time makes sense.
Yeah.
Where we do need to, I mean, just going off at a slight tangent, where we do need to be careful about periods of liability is if you are entering into a collateral warranty or anything akin to a collateral warranty, duty of care agreement, letter of reliance, etc., that can't be for a period of liability longer than the original appointment. So you can't enter into an appointment with a 6-year liability period and then agree to provide a collateral warranty for 12 years.
Exactly.
That extra 6 years worth of liability isn't going to be covered. And that's where engaging with your legal advisors like Derryn with your broker is really important, because we quite often identify when we look at contracts that have been presented to us, we identify the fact that the original appointment was signed underhand, yet we've got a collateral warranty as a deed where there's a 12-year liability period, and that creates an uninsured risk.
Absolutely.
And you perhaps wouldn't realise that. No. You'd think, well, it's a collateral warranty, everyone's asking for collateral warranties, and that's where the nuances of professional indemnity, how it operates is really important for you to have an understanding there.
It is.
So I'd love to talk to you a lot more on this. It's a subject I'd love to talk about, but I think we probably ought to look at the Q&A for any questions that...
Q&A or chat?
Let's have a look, see what we can find. There we go.
Just make that go away. Complicated things on the screen. Right, let's try. We've got 2 options here. So, anonymous attendee. In the last few years, our PI has had a number of fire safety exclusions. Are you still... I think we've covered that. That was quite early on. Somebody else, we found an each and every claim cover difficult to find, particularly for our subcontractors. That is a problem. Is each and every cover now more readily available? And if so, does it cost a premium over the aggregate cover? That's a very good question.
Okay, so you've used the term there, subcontractors. So I'm assuming that these are firms who are involved in contracting work but have got a design responsibility. And that there's a particular type of PI cover that isn't as wide and operates in a slightly different way called design and construct PI, which is what is offered to people, contractors who have got a professional responsibility for certain types of work. So, if it's electrical engineers where they do the design work and they do the installation, for example. Now, for what we call D&C PI cover, the market generally, unless you're involved in lower risk work, so M&E work, for example, is considered to be low risk. If you're a building contractor, for example, or you're involved in higher risk contracting work, the market is still only comfortable offering cover in the aggregate. That is changing. Market conditions are improving every year. And while we're in what we call a soft market, the ability to buy that cover on each and every claim basis, or any one claim, sometimes it's known as, that's more likely to be possible. But the starting point for the market is in the aggregate. And there, if you are a subcontractor and then you manage to achieve that each and every claim basis, you've got to ask yourself, will I still be able to achieve that year after the year after that? So I think when as an employer or a main contractor asking subcontractors for certain types of cover, I think being realistic as to what they're likely to be able to maintain is important. Because if they all of a sudden you're asking them to insure something that might not be insurable, that doesn't serve anybody. So it's just being mindful of that.
Yeah. So from my point of view, we would always draft, although we'd always ask for each and every, because obviously, that would be the best for our developers and funder clients. But there's always going to be a clause that says if you can't get it, what I call the what if clause.
Yeah. So what I would say there, if the subcontractors are coming back to you saying, look, we can't get that, it's an aggregate basis of cover. The important thing to remember with an aggregate cover is that limit gets eroded as claims are accepted and paid. So, for example, if that subcontractor's got £5 million worth of cover and they have a £2 million claim paid, then they've only got £3 million worth of cover left. Is that going to be enough for the potential claim that you might need to bring against them is the question that you need to think of. And if you think, actually, that doesn't really give us much comfort, then that's where you would say, okay, the aggregate limit is fine, but we need you to buy more.
We need to buy more. And that's what we say, and that's the problem. And it then gets all tied up in all sorts of other things that it's PI doesn't exist in a vacuum, and it gets hideous from our point of view. But that is the whole aggregate. So, but you can have in the aggregate with round the clock reinstatement.
You can. So we're going into a bit more technical territory there, but if you do need to have each and every claim basis of cover, then the equivalent is in the aggregate with what's known as unlimited round the clock reinstatements, which is the same or the equivalent of an each and every claim basis, but it's subject to the market offering it, and not everybody likes to offer it. And then it comes at a cost, because effectively you are paying for that broader basis of cover. But what it means is you have to have more than one insurer involved, because that risk gets passed along and it goes round the clock back to the original insurer. So it's quite a technical thing. So it takes about 5 or 10 minutes to explain that fully.
So do that offline, because I'm fascinated.
We'll talk offline, and perhaps we'll pick that up at a later time. But yes, that is a workaround, and I've done that for clients many times. So have we got any more questions then? Yeah.
For a chartered surveyor, can you explain the long stop period and how the insurance policy covers this? Are we talking runoff, do you think?
I'm not entirely sure from that. Or it potentially is, how long does a potential claimant have in order to bring a claim, possibly?
So there's two things. One is the limitation period for a particular contract, whether it's a warranty appointment or whatever. And that will be, the statute will kind of set it, and the contract will also confirm it, and they might be slightly different. The other issue is if you're intending to retire, for example, if you're a sole trader, you would need to be carrying what we call runoff cover, which means that because PR works on a year of claim basis rather than a year of default basis, for the time that any unexpired time on limitation time on contracts. So if you signed a contract a year ago that had 12 years on it, you've got 11 years in which they might make a claim. So you need to be carrying some runoff cover for the length of time that you are contractually at risk. Now, usually that's of lesser premium because you're not taking on new work, so it's just historical risk. So the brokers will presumably look at what the contracts are and come up with a figure according to that. But these days, if you're doing work for which the 15-year limit applies, then from the point of view of saving your house, you need to be carrying it for 15 years. But so for runoff, you need to be looking at what contracts you signed up to and where it ends, what the deadline is for people bringing claims. Make sure you're covered for that.
Yes, and also complying with the RICS rules. They've got very strict rules on runoff cover, so that's the important thing. And again, broker would guide you on that. But the premium does come down year on year, as you say, Derryn, because there's less risk. There's no new work to be insuring, so the cover comes down proportionally year on year. Great. I think that's it. So thank you, everybody. Yeah, appreciate you listening to us have our chat. And yeah, this is an ongoing series. So if there are topics that anyone would particularly like us to address in future conversations, then please let us know. But we will say goodbye and thanks again.
Thank you very much.